law school, you know, they do well, they would be great lawyers, and then they can't find an articling position, and so they can never become a lawyer. I don't think that that's a situation that can be tolerated. But I'm certainly open to ideas. I think that there are probably other creative ways. I just think it's not a solution to simply say, yes, we need the profession to generate more positions, because it's not happening. That was the hope, I think, a couple of years ago when the Law Society did the report, but the profession is just not generating enough positions, and the situation is only going to become worse. There are a lot more foreign-trained lawyers now. We're getting, you know, new law schools, so we all need to think creatively. Hello?
Omar, are you there?
I am. Can I get my slide deck too?
Go ahead. Yeah.
So just by way of background, Catherine had already touched on some of the issues that I'm going to be speaking about. We can get the next slide, please. Just a little bit about myself. I'm currently articling at a small litigation boutique in Toronto. So I'm actually in the middle of many of the issues and challenges that my peers are facing. But I'm very fortunate that I didn't have incredible difficulty finding an articling position, and I think I'm very happy with the place that I'm at. One of the other roles that I have, though, is I'm the articling student ambassador for the Toronto region with the Ontario Bar Association. So generally, people will approach me with their concerns and their issues relating to articling and the licensing process in general. And prior to this presentation, I did solicit feedback and spoke to over a dozen people. And keeping in mind as we go through these slides, it's not necessarily positions that I'm advocating, but it's positions which, or issues that people wanted me to raise for the session today. If we can get the next slide, please. So I tried to aggregate the issues that I heard from speaking to different students into three main groups. And essentially these are the three major themes that I kept on hearing repeatedly. First of all, that there isn't enough articling positions. Second of all, what the actual process or regulation of student hiring is itself flawed in some ways. And the third is abuse, and I'm using that word because that was the word that was used towards me, of articling students through their course of employment. Next slide, please. So I did get figures for 2010 to 2011 from the Law Society, and there are approximately 150 people who were looking for an articling position but were unable to find one. Now, in interpreting that data, we have to keep in mind that there may have been some individuals who started to look for an articling position and then abandoned that process, so that number might actually be larger than what it reflects. And keeping in mind what the number of graduates are in the province every year, that still is a relatively high number. And I know quite a few of these individuals only found that position towards the very end, so it was a last-minute sort of thing. Catherine had mentioned, you know, we do have new law schools. There's Lakehead University has recently received the approval of the Federation of Law Societies of Canada, which is a next step towards becoming a new law school. Thompson Rivers, even though it's out in BC, is starting in September 2011, and the University of Ottawa is actually beginning a second cohort in 2012. Now, even though I have, you know, a law school here in BC, it's good to keep in mind that Ontario generally has the major population and the younger population in Canada. So inevitably and invariably, a lot of the law students all across Canada do come from Ontario, and after graduating, they do want to article quite frequently back in the province. So it is something to keep in mind that even though we do have law schools opening up elsewhere, that this still will affect us. Next slide, please. The actual regulation of student hiring, there are a number of documents the Law Society provides to law firms which provide guidelines that are intended to protect students. Essentially, they want fair dealing between firms, because firms, there are large firms and small firms and firms with varying levels of ability to recruit students. But they also want to minimize the interference with the studies, and understandably so. Some of the ways in which the Law Society does this is provide strict timelines in which the law firms can interview students and provide offers. The interviews themselves are limited in length, and there are some fair hiring guidelines, specifically relating to human rights issues. Now, there is also a discrimination and harassment council contact with the Law Society for issues that do emerge or arise in this process. But as one student told me, we're in a profession where when people complain about issues, we're being trained to advocate on their behalf. But if we attempt to complain about issues relating to gender or sexual orientation or ethnicity, we're essentially going to be blacklisted. And we're not going to have opportunities in this field. So whether or not these avenues of feedback to the Law Society are effective or not is questionable. Next slide, please. The last major issue was the actual articling process. Catherine mentioned work-life balance, but I think it's beyond even just work-life balance. It's an issue of often extraneous hours, and unreasonably so. And I think we have a sense of normalcy about this process just because we've all gone through it, and we expect that as being part of the process of becoming a lawyer. Whether or not that's right is something that we should be willing to reconsider, especially if we keep in mind that we are having a far more diverse law student body, including people who have children or family responsibilities, where these types of positions with a law firm are simply not possible. I can also relate, there were stories told to me about comments of a sexually inappropriate nature, racially inappropriate comments or treatment, and this is in the past year. So, I mean, these have all been related to me in one form or another, and they didn't really feel that the Law Society would be able to assist them, and there was also concerns about challenging the law firm directly given employment issues. So essentially it is a potentially a vulnerable population. Some have suggested that ESA minimum standards should be applied or at least be reviewed in application to articling students. And there isn't a union. Now, it might be of interest to some of the participants to know that there was actually in Ontario at some point an articling student union. But since lawyers cannot be in a union under the Labor Relations Act, once they got called to the bar, it was disbanded, so there was an issue of continuity. But it is there as I guess, an issue that has, or a solution that has emerged in the past when articling students felt that things were getting too bad. I also should, as a nature of my role, pass on that there were several students in the past year who voluntarily chose to terminate their articles, given the type of scenarios or situations that they found themselves in where they found that the treatment was inappropriate. Next slide, please. And just in closing, this is a comment provided to me by someone who was an NCA student from the U.S., visible minority, and they wanted me to pass this on verbatim. So it does, I think, illustrate many of the issues or concerns that I think I've just been talking about for the past couple minutes. I'm not going to read it there, but it is there for you. And this individual's suggestion was abolishing the articling program, which I don't necessarily think needs to be done, but I certainly think it is worth looking at these issues and seeing how we can necessarily address it. And if they cannot be addressed, then maybe providing alternatives, as Catherine has mentioned. Thank you.
Thank you, Omar. So now we'll turn it over to some of the questions. And for those who are listening, my name is Glenn Kous. I'm the editor of the Law Times. And on your control panel for the webinar, there is a chat function where you can submit questions. So for those who wish to do that, if you submit those, I'll ask those on your behalf. And we have a number of questions for the panelists themselves that I'll be asking. So I'll go through each person. I'll ask the question, and try to keep it somewhat brief as we don't have too much time. But the first question deals with the IT, the information technology revolution, and some of the issues that Richard Susskind has talked about in terms of the legal profession needing to adapt to some of the IT solutions that are coming about. So I guess I'll throw that out there and start with Mitch Kowalski to ask whether the Law Society is adequately dealing with some of the issues that Richard Suskind's been talking about.
Thanks, Glenn. The short answer is the Law Society doesn't have a clue what Richard Susskind is talking about, and that is a concern. That's one of the reasons why I'm running, is if you read The End of Lawyers, I mean, the title is obviously provocative and on purpose, but it is meant to make us think about our profession and where we're going to be down the road. And that's why I said the next 4 years are critical, because we have to be much more efficient and much more business-oriented in how we deliver our services. One of the classic lines that Susskind uses in his book is that law is not here, to make lawyers rich. I'm paraphrasing. Okay, law is here to serve the public, and we have to serve the public in whatever way is most efficient and cost-effective, and that includes how we structure our law firms. Should partnerships even be the way law is delivered? Shouldn't it be delivered in a different way? I mean, if we had to create legal service delivery providers today, would we use a partnership model, or would we use a different model? Would we really be structuring it by using billable hours, or would we be outsourcing to India or the Philippines using LPOs? I mean, these are issues, and it goes beyond IT. IT, I think, is the easy answer, but it goes far beyond IT in terms of the things that we can do to make our profession not only better for the public, but better for ourselves. And that will address a lot of the work-life balance issues, the diversity issues, et cetera, et cetera. So I'll leave it at that, but the short answer is the Law Society is lost on this issue, and it really needs benchers who are cognizant of what's going on here and around the world to be elected. Thanks.
Susan Hare, can you tell us your thoughts?
Yes, thank you. I think the first speaker was pretty accurate in saying that the Law Society really didn't have much clue as to the message of Richard Susskind and others like him, and in fact, a very defensive stance is sometimes taken by some lawyers in the profession and some people at the Law Society. I think diversity has to include not only in terms of people diversity, but in terms of ways to conduct the practice of law. Diversity it's going to happen, and it'll drag everybody kicking and screaming through the door whether people want to or not. And I think that's what's happening. So I think it's time for convocation to have a full, not only convocation, but the profession, to have a full discussion and debate on these issues, because outsourcing is already happening. The Certified Specialist Program at the Law Society